All right, my name is Jake Bryant. I am the Group 12, and the topic I'll be presenting tonight is tort reform in the healthcare industry. So, just to start off, kind of a review of this week's lesson, just briefly talk about healthcare law and ethics, and why do we need to better understand healthcare law and ethics. And regardless of our future professions, whether it's to be a doctor or PA or PT or even to work in healthcare administration, it's important for us to understand healthcare law and ethics. And according to our chapter this week, chapter 7, we need to study healthcare law and ethics so that, one, we can help function at the highest possible professional level, providing competent, compassionate healthcare to patients, and two, to help us avoid legal entanglements that can threaten our ability to earn a living as a successful practitioner or manager who is trained to administer medical or healthcare service to patients. So just a brief review as we move into kind of talking about torts and whatnot. I thought it was important that we cover that because healthcare law and ethics is intertwined with tort. So first off, tort. What exactly is tort? Not tart like Pop-Tart, but actual tort. Our book describes it as a wrongful act, not including a breach of contract, let me back up. One aspect of healthcare law and ethics revolves around tort law and reform. To understand the controversy surrounding torts, it is important to know what a tort is. The website dictionary.com describes a tort as being a wrongful act, not including a breach of contract or trust, that results in injury to another person's property, reputation, or the like, and for which the injured party is entitled to compensation. So it's pretty, it's kind of broad, but it does define very specifically what a tort is. Wrongful acts targeted at one person or group or property that causes harm. It can be physical, it can be reputation or any of the like. And to move on, there's two types of torts. There's intentional and there's unintentional. And the first type of tort is an intentional tort. An intentional tort is just as it sounds. It's intentional. Harm is intended, or a person knowingly performs an act that creates damage to a person or property. And our textbook describes it as it can either be assault, battery, trespass, fraud, deceit, invasion of privacy, or even misuse of legal procedure. I want to give a little example of an intentional tort in the healthcare industry. So, for example, my wife, Melanie, she competes in Olympic weightlifting. She had up until a few years ago, and she was strong. She was good enough that she was headed towards at least the Olympic trials, the U.S. trials. And because of the wear and tear of the sport, it had taken this huge toll on her wrists. And she found out that her carpal tunnels were collapsing, and she needed to have surgery on both of her wrists. It's often that one wrist will have problems, and it's less often that both wrists will need that surgery. Most people that do have the issues with both wrists will elect to perform one surgery at a time. That way that they can heal, their body can do what it needs to, and then they can move on to the other wrists. My wife, Melanie, who wasn't my wife at the time, she lacked insurance and was paying cash for her surgeries. So she decided to have both wrists done at the same time so that she could save money in the process. Now, for the sake of my example, we'll say that Melanie chose to get one wrist done at a time. And we'll say, for example, that she was going to start with the left wrist. For the purpose of the example, she established it beforehand with the surgeon that he was going to perform the surgery on the left wrist. For whatever reason, the doctor decides during the surgery or before the surgery, in the midst of the surgery, to perform surgery on the right wrist instead of the left. He knowingly performs the surgery on the wrong wrist. There were no complications, and the surgery had been deemed a success. Even though the doctor would have fixed the problem in the right-handed wrist, he did not perform the surgery as it was agreed upon on the left wrist. This can be considered an intentional tort, a battery to be more specific. If this had actually happened with my wife, she could have sued the doctor for malpractice. And it's precisely these sort of frivolous lawsuits that help to explain why there's a need for tort reform. We're going to get into that in just a couple minutes. The second type of tort is an unintentional tort. These are the most common, and the PowerPoint presentation from this week's reading, titled Healthcare Law and Ethics, describes unintentional torts as being acts that are not intended to cause harm, but are committed unreasonably or with disregard for the consequences. And I've got an example of an unintentional tort. It's a little bit shorter, but it takes place actually quite a bit in long-term care facilities across the nation. And in long-term care facilities, there are residents that are ambulatory, meaning they have no problem getting around on their own. There are those that need assistance with ambulation, whether it's being pushed in a walker or help getting to the walker and from the walker. And then there are residents who can't ambulate at all, even with assistance. These are paralyzed residents, or they're residents that just can't function in a normal capacity. And though the residents that cannot move on their own need to be moved every couple hours to ensure circulation is maintained and that a pressure ulcer or a bed sore doesn't form. In a busy day at an LTC or a long-term care facility, a nursing assistant may forget to help a paralyzed resident with position change. That resident's risk for developing a pressure ulcer increases with each moment they are left in the same position for too long. Let's say, for example, that a pressure ulcer forms and furthers to an infection, causing serious harm. The nursing assistant would be guilty of unintentional tort. More specifically, they would be guilty of negligence. And most unintentional torts are actually what they would consider negligence. Now, the nursing assistant, they didn't intentionally leave the paralyzed resident stuck in that position. They were busy and were distracted with other residents or responsibilities. However, they could be sued because this would be considered negligence. And as I stated earlier, this is a very common situation in long-term care facilities and even in hospitals across the nation. So moving on to tort reform. Tort reform, I believe, is a necessity. Because of frivolous lawsuits and the need for physicians to have increasing insurance to combat these lawsuits, the system needs to be reformed. The issues surrounding torts are increasing the cost of healthcare in America. They're not a large or huge chunk of the issue, but they play an integral part in the ever-increasing cost of insurance. Payouts from lawsuits are generally comprised of three different components. Excuse me. Payouts consist of compensation for lost income, 1, 2, medical expenses, and 3, pain and suffering. It is easy to determine the dollar value associated with the lost income and the medical expenses. However, unfortunately, pain and suffering is a much more subjective component to assess. A capable attorney can play to the hearts and emotions of the jury in a lawsuit, thus securing a higher payout for pain and suffering. In addition, most attorneys generally take a percentage of the award given. The more an award is, the higher the fee will be for an attorney or a law firm. In this sense, they are encouraged to create large suit amounts. And malpractice lawsuits potentially drive up the cost of health care, thus affecting the taxpayer and so many individuals other than one or the few that benefit from these lawsuits. Physicians are required to pay higher malpractice insurance. Simply put, a physician is going to pass on that cost to the patient. Continuing on with tort reform, a PDF titled Medical Malpractice Tort Reform was put out by the Association for Medical Imaging Management. In this PDF, 4 attorneys describe some of the pros and cons of tort reform. They stated, proponents of medical malpractice tort reform argue that as a result of changes to laws governing medical malpractice claims and their associated awards, malpractice insurance premiums would decrease. They further argue that lower insurance premiums for healthcare providers would increase the number of practicing physicians, lower the cost of healthcare for consumers, and result in an overall improvement in available medical care. And as we'll see, this kind of happened in the state of Texas. Many states across the nation have issued their own sort of tort reforms, and Texas is an example of a state in dire need and a state that has successfully reformed their tort. It's traditionally been initiated tort reform on the state level. It hasn't been until recent years that the federal government has been involved in the tort reform. And as I said, Texas was among the many states that worked to reform the issues surrounding torts and malpractice. Texas has been successful on the state level at making improvements. The reform in Texas started in 2003. At that time, according to the Heritage Foundation, 1 out of every 4 doctors in Texas had a malpractice claim filed against him or her each year. In addition, 85% of all medical malpractice claims failed, but cost more than $50,000 to defend. The number of medical malpractice insurers in Texas dropped from 17 in 2000 to only 4 in 2003. One of the 4 was the state of Texas as the insurer of last resort. In addition to those costs associated with that, people were literally coming from all over the country to get in on the suits. This caused doctors to pick up and leave or to retire or to cut back their own practice. And because specialties were targeted the most, such as OBGYN and pediatrics, at one point Texas had 100 Texas counties that did not have a pediatrician and 154 that did not have an obstetrician. And think about that. That's just incredible. 100 counties in Texas did not have a pediatrician and 154 did not have an obstetrician. In 2003, Governor Rick Perry, backed by a Republican-led Texas House of Representatives, worked to create what they called the House Bill 4, or HB 4. Part of this bill included a $250,000 cap for non-economic damages, or those pain and sufferings that we talked about earlier. Because of the changes, the number of physicians, doctors had doubled since 2003. In 2013, Texas doctors were paying about half the premium amounts than they were 10 years prior to that. Tort reform and Obamacare. I wanted to discuss this a little bit more in detail. I struggled to really find the motive behind it because tort reform, there was an opportunity for tort reform to be included in Obamacare. And there was times even that President Obama had actually hinted at the fact that he would be willing to seriously take a look at some tort reform. When it came down to it, I only found a little bit of information regarding why President Obama would allow tort reform or would not allow tort reform to be included in the 2009-2010 debates on healthcare reform. I found a couple articles that basically surmise the same thing, and that was that it all came down to campaign donations. In an article on CNN.com, Dr. Anthony Yoon described the motives behind not including tort reform in Obamacare. He said, since 1990, the American Association for Justice has given 92% of its $36.8 million in contributions to Democrats. It is opposed to malpractice tort reform for obvious reasons, and I suspect that it may have played a significant role in the absence of malpractice liability reformation in the Affordable Care Act. So 90+% of their donations that they provide go to Democrats or liberal-leaning representatives. And it's connecting dots without a whole lot of information to I guess, back that up. But it appears that Obama did that because they had donated so much to his re-election campaign. So with that, that's the end of my presentation. So,
great, thanks, Jake, for that. You obviously did a lot of research and did a very good job. Tort reform has been a hot topic in healthcare for a while now, and there's a lot of drive for change in that field. But you did a great job of covering that. So I had the question that I've been asking everybody at the end of these is, what was something that you learned as you're doing your research that kind of surprised you or that stood out the most to you about tort and tort reform?
One thing that I didn't mention in my presentation that was kind of troublesome is that the amount, depending on where you look, everybody's different in the type of numbers that they provide, but the amount is in the billions of dollars of money that is wasted on either litigation or payouts, all associated with tort reform. And some representatives feel that that's just a drop in the bucket, that doesn't matter. But that's a lot of money, billions of dollars in 1 year. I think one place one website had attributed it to about $60 billion a year is spent. And though our national debt is very, it's much, much higher than that, and the amount that is spent on healthcare every year is in the trillions, it's still billions of dollars. And over the long run, that makes an impact. And I personally believe that it's driving premiums up. And I don't know. I was watching the debates the other night, and Donald Trump was talking about, the states and the lines and healthcare, and he wasn't very, very clear on what he was trying to express. But basically, he was saying that I believe that it needs to be in the hands of the states.
Right.
I don't necessarily support or understand what he's talking about, but having gone through this presentation and my research for this, it became a little more clear that the federal government needs to stay out of this. Let the states decide. California's had a successful, reform for 30 plus years. Texas has done well for the last 10 years. So allow the states to do that and take example from other states. So.
Great. Yeah, no, tort reform and these lawsuits are expensive. I mean, just in those, but I like how you mentioned that, you believe it's driving up premiums, and I highly agree with you on that. I mean, physicians are having to get more and more liability insurance, malpractice insurance, and those premiums go up, and in turn, it's just a cascading effect. So,
Right.
Definitely agree with you on that. So, all right. So I'm going to stop recording now, Jake, but just hold on for a sec.